तो भाई सपना that is the motto.
So let us continue, dear students. Now let's understand types of laws. We have criminal law, of course, law related to crimes. We have civil law, the law relates to disputes. Then we have common law, we will discuss in details. Then we have principles of natural justice. When we discuss criminal law, we can understand it by these: murder, rape, theft, fraud, cheating, and assault. These are some examples of criminal offenses. For detail, you can read the Indian Penal Code 1860. The Indian Penal Code 1860 defines the crime. So, murder is defined as a crime, rape is defined as a crime, theft is defined as a crime under various sections. We commonly have known 420 कि ये 420 है. So this is also a section under Indian Penal Code. So 420 is a section of cheating and fraud. So Indian Penal Code tells us about the crime, its nature and punishments, whereas the Criminal Procedure Code 1973 defines exhaustive procedure for executing the punishments of the crime. Let me ask you a question. Punishment is mentioned in Indian Penal Code or punishment is mentioned in Criminal Procedure Code? The answer is punishment is mentioned in the Indian Penal Code. The Criminal Procedure Code defines the exhaustive procedure or executing the punishment of crimes. Civil law, matters of disputes between individuals. So, dispute between A and B, both are individuals, or organizations. So, A, B, C company versus XYZ company. So, these are organizations. Dispute between ABC versus XYZ are dealt with under civil law. Here, the courts will enforce if A agrees to sell B his bike for 50,000 and later refuses. So B is going to court to get it enforced. Judge Sahab, please request A or please order A to fulfill the promise which he gave it to me. What was the promise? The promise was to sell the bike for 50K. So basically, in a contract, rights and duties emerge. For example, A had the right to get 50,000 from B. Okay. And A had the duty to sell the bike to B. Similarly, B had the right to receive the bike and the duty to pay 50,000. So these are the situations where rights, duties are created in contract. We have also noticed that promises were exchanged between A and B. We also call it reciprocal promises. Why reciprocal? A promised something to B, B also promised something to A. So we have understood the rights and duties. And now, if there is a violation, then courts will enforce the certain rights and obligations which were created through contract between the parties. Why will the court enforce? To maintain justice. Law is a set of obligation and duties imposed by the government for securing welfare and providing justice to society. So securing welfare and providing justice. So A and B, they entered into a contract, and B is not fulfilling the promise. So A has the right to approach law. That means approach the judge and get remedy. This will ensure social welfare and this would ensure justice. So if there is a violation of certain rights and obligations, there would be a civil suit. So we can conclude that civil law primarily focus on dispute resolution rather than punishment. If the case is of murder, rape, theft, fraud, cheating, the remedy is punishment. But if the cases are of breach of contract, non delivery of goods, non payment of dues to lender or seller, defamation, breach of contract, and disputes between landlord and tenant, the idea of the court is to resolve the dispute. The act of process and the administration of civil law are governed by the Code of Civil Procedure 1908. Civil law can further be classified into law of contract, family law, property law, and law of tort. So, civil law can be further classified into 1, 2, 3, 4. So, memorize it. So, I hope you can easily distinguish between civil law and criminal law. Now, let's try and understand common law. When a judge passes a judgment. Okay. Which judge? The judge of Supreme Court. So that judgment will be binding upon the courts within the territory of India. It becomes common law. This power is derived by Article 141 of the Indian Constitution. So we need to respect Indian Constitution. Article 141 states that judgment by Supreme Court will be binding upon the courts within the territory of India under Article 141 of the Indian Constitution. You might get a question, what is the doctrine of common law? So the answer would be stare decisis. The doctrine of stare decisis is the principle supporting common law. It is a Latin phrase that means to stand by what is decided, and decided by Honorable Supreme Court. The doctrine of stare decisis reinforces the obligation of courts to follow the same principle or judgment established by previous decisions. There are various high courts. If high courts give an opposite judgment, will it not be disrespecting Supreme Court? So it becomes a common law. Once the Supreme Court gives a judgment, it becomes binding upon the courts within the territory of India. It becomes a common law under Article 141. So all the other courts need to stand by which is decided. The courts are under obligation. Which courts? The high courts, the other junior courts, to follow the same principle or judgment established by previous decisions while ruling a case where the facts are similar or on all four legs with earlier decision. It is cut, copy, paste by high courts following the judgment of Supreme Court where the facts are similar. Let's understand the principles of natural justice. Imagine there is a son, there is a father, and there is a grandfather. The son has certain dispute with his father. The son goes to the grandfather. The grandfather, you decide whether I am right or my father is right. So this is quite natural. But imagine if the father says ki I am your baap and whatever I say is final and binding upon you. So that is against the principle of natural justice, which means no one should be made a judge in his own cause. Here the dispute is between A and B. So A and B. So how can B become the judge? So this case would be judged by a third party called C. Because it's a rule against prejudice. B will always try to favor himself. So let there be a neutral person. Now also imagine A versus B. Now B has a dominant position and B does not allow A to speak. You keep your mouth shut. No. So in the case of natural justice, opportunity should be given. Basically, proper hearing should be done. So A should be allowed to represent his situation. Let's hear A out. The other party should be given a fair hearing. So, principles of natural justice: you cannot be the judge in your own case, and you have to allow the other person to present his opinion. So, a reasoned decision are the rules of natural justice. Reasoned decision. A judgment can override or alter a common law, but it cannot override or change the statute. There are situations where the previous judgment by the Honorable Supreme Court are overturned. So, a judgment can override or alter a common law. Okay. So basically, courts, they change their stance. They change their stance. Is it possible? Yes, because the changing times presents the situation in the modern context, but it cannot override or change the statute. Statutes are laws created by Parliament. Basically, these are constitutional laws. So, as we had already discussed, we have to give full respect to Constitution. So, Constitution versus Supreme Court. Who wins? The Constitution will win. So we stop here. Next day we will start with the topic enforcing the law. Thank you. Bye bye.